That's too bad. In my dreams, I have a plan. If I got me a wealthy man, I wouldn't have to work at all. I'd fool around and have a ball. Money, money, money must be funny in the rich man's world.
Hello everyone, my name is Rachel Castillo, and today I want to talk to you all about debt. Now, we've probably all heard of student loan debt, credit card debt, mortgage debt, auto loan debt, medical debt, payday loans, home equity loans, home improvement loans, small business loans, tax debt, legal and court ordered debt, overdraft fees, utility bills, child support, store credit, and of course, the national debt. It's like the 31 flavors of American debt, but not nearly as delicious. But hold on to your pocket change because there's more. Today, we're talking all about employer-driven debt. As you may have guessed, employer-driven debt refers to debt that people face through their employment. Now, you might be thinking, well, that's odd. Aren't employers supposed to pay their employees and not the other way around? And of course, you'd be right. It's like the ultimate capitalist plot twist. You work for us and you pay us for the privilege. Now, according to the California Department of Justice, employer-driven debt is a real problem and one that has grown substantially in recent years, stifling competition in the labor market and holding workers hostage in jobs they would otherwise leave due to low pay and substandard working conditions, which to me sounds an awful lot like indentured servitude. And I don't mean that flippantly. Indentured servitude was this charming little practice from centuries ago where people would basically trade their freedom in exchange for passage to the new world. It was the original one-way ticket, but the catch was once you got there, you had to work off your debt before you could claim your passport to personal freedom. Now, when we compare this to today's employer-driven debt, you're not exactly trading your freedom for a boat ride, but you might find yourself bound to the job because of debt obligations, just like an indentured servant. It's a bit like saying, hey, we hired you, but now you owe us, and there's no quitting until you've paid off your freedom fee. It's like indentured servitude with a shiny new 21st century twist. Indentured employment, if you will. And spoiler alert, these practices tend to target the very people who are already juggling all the other flavors of American debt. Women, people of color, low-wage, and immigrant workers are the primary targets, with employer-driven debt being found in healthcare, trucking, aviation, retail, and service industries. The rising prevalence of employer-driven debt got the attention of the Consumer Financial Protection Bureau. Last year, they launched a full-blown investigation into the predatory practices associated with employer-driven debt. And perhaps unsurprisingly, they received a flood of comments from individuals and organizations. According to workers, when it comes to employer-driven debt, there is a labyrinth of unique harms. And this is true because employer-driven debts are inextricably linked to a worker's employment, and the worker's ability to repay the debt is controlled by the issuer of the debt itself. CFPB comments also tell us that workers are rushed into signing these agreements that they don't fully understand, with terms hidden in the fine print. Employers might even change those terms without the worker's awareness. Now you might be thinking, well, that's kind of their own fault, isn't it? Everyone knows you should read the fine print, right? But commenters in the investigation also noted that debts are often imposed as a mandatory precondition for employment, which restricts workers' ability to negotiate terms and conditions before accepting the job. And it's hard to believe that's just a coincidence. The financial bonds that are created between employer-driven debt and workers' employment are reminiscent of a bygone era. It's like stepping back in time to the days of company towns, where the company controlled not just your job, but your entire existence. In company towns, workers were often paid with company scrip, which is essentially an employer's monopoly money that could only be spent in company-owned stores. You'd work hard for your tokens, and then at the end of the day, you'd find yourself handing them back to your boss just to cover your basic needs.
You load 16 tons, what do you get? Another day older and deeper in debt. St. Peter, don't you call me, 'cause I can't go. I owe my soul to the company store.
Indentured servitude was outlawed in the 1800s, and paying workers with company scrip was made illegal in 1938. But when we face the contemporary realities of employer-driven debt, we see that when it comes to the exploitation of labor, history has a way of echoing through the ages. So let's take a closer look at training repayment agreement provisions, or as they're aptly referred to, TRAPs. These sneaky little contractual clauses make employees repay their employer a set amount if they leave or get fired within a specific time frame, usually 1 to several years. Some TRAPs even let employers collect the training debt if the worker is fired without cause. Now, employers claim that TRAPs are needed to recoup the cost of teaching invaluable skills to employees who dare leave prematurely. But here's the thing, the supposed cost dramatically exceeds the actual value of the trainings offered because the skills learned are rarely transferable. And many workers are bound by these contracts even after receiving zero training. In fact, some TRAPs actually admit that the training is just on-the-job experience. TRAPs are pretty effective at keeping employees stuck in jobs they might otherwise leave just by the mere threat of enforcement. But that doesn't mean that TRAPs are just idle threats. In fact, employers that have successfully sued their employees, they've required a metal polisher to pay $20,000 to leave the company early, truck drivers to pay $8,000 for early departure, and an IT trainee on a $23,000 a year salary to pay $30,000 for leaving before 2 years. And TRAPs are more than just financially burdensome for individual employees. They're also a direct assault on workers' ability to organize. They can have a chilling effect on employees' willingness to quit and infringe on workers' rights to engage in collective bargaining. The ability to withhold labor is a critical element in any organized labor campaign, and this ability is jeopardized when employers wield TRAPs as financial weapons. Now, TRAPs aren't exactly the new kids on the block, but their rise in lower and middle wage industries most certainly is. Back in the 90s, when TRAPs first came on the scene in significant numbers, they were predominantly associated with high-wage, high-skilled occupations. You might think it's fair play when a company foots the bill for a master's degree in a white-collar job, and in return the employee pledges loyalty or repays the education fees. But that's not what we're talking about here. Today, TRAPs are used in industries where workers are already underpaid, hitting women, immigrants, Latine, and Black employees the hardest. Employers are using TRAPs for truckers, nurses, salespeople, bank workers, and more. These jobs, once middle class with robust union presence, now face financial struggles, with unionization levels having declined significantly. And employers know exactly what they're doing. Non-compete clauses, which block workers from working for competitors, have recently faced increased scrutiny and regulation. In response, a roofing trade association said the quiet part out loud, urging its members to swap non-competes for TRAPs because they thought the former would be harder to enforce. It's a classic case of, if you can't beat them, find a loophole. And now we consider the healthcare industry. During the height of the pandemic, employers turned to TRAPs to ensnare nurses and other healthcare workers during a time when nearly 1 in 5 of them had quit or otherwise left their jobs. Many had fled due to unsafe working conditions, resulting in more than 3,600 preventable deaths in the first year of the pandemic alone. And let's be honest, that's probably an undercount. Now, National Nurses United gave us all the dirt on HCA Healthcare, the largest for-profit healthcare employer in the world. HCA is using TRAPs to reduce nurses' bargaining power. They require fresh-faced, newly graduated nurses who, by the way, are fully licensed and often already working as RNs to complete the company-run STAR RN program to receive so-called nursing coursework. Their trap involves taking out a $10,000 promissory note, accepting pitiful wages, and as a cherry on top, no benefits. And after completing the program, they're shackled to HCA for 2 years or required to pay back the note. And it's not just HCA. Other healthcare giants like Tenet Healthcare and MedStar Health are also throwing their hats into the trap ring, with payback amounts ranging from $5,000 to $50,000. And these traps have real-life consequences. In July of 2020, while the country was busy banging on pots and pans for healthcare workers, Parkland Hospital in Dallas decided to sue almost 24 nurses who left the hospital before completing their 2-year agreement. Healthcare providers and hospitals defend these traps, claiming they offer critical education for new nurses. Yet, this so-called education often consists of just a monthly webinar on basic things like orientation or stress management. And seriously, why do you think the nurses are stressed out in the first place? National Nurses United call it what it is, a facade to handcuff nurses to their employers. Now, call me crazy, but I'd rather have a happy, well-rested nurse taking care of me in my most vulnerable moments. At the end of the day, let's be honest. Nurses and healthcare workers don't need a standing ovation. They need a damn paycheck that reflects their worth. And it's not just about fair compensation, it's about freeing them from the shackles of employer exploitation. Now, if you think what healthcare employers are doing to their workers is bad, just wait, because now we're turning to the trucking industry. And I have to warn you, some of this is going to be pretty hard to hear. The sector, notorious for its grueling conditions and low wages, has seen decades of deregulation since the 80s, leading to terrible working conditions and a revolving door for truckers. According to the New York Times, truck drivers had an annualized turnover rate of 91% in 2019. Many of the largest trucking companies lure potential truck drivers into their training programs with the promise of a free or paid training and a high-paying job afterwards. Instead, their fast-track training programs either binds them to companies for a period that can last anywhere between 10 months and 2 years, or cost them thousands of dollars with sky-high interest rates. Take CRST, the Transportation Solution Inc., for instance. CRST heavily advertises its trucking school, promising a steady trucking career and a large signing bonus with ads that say, "No experience, no problem, get paid to train." But, as you may have guessed, these promises are no more than smoke and mirrors. Former CRST trainee Jim Simpson described the training conditions as brutal. He said calling the program a training at all was a stretch. As he put it, they didn't really prep you for the commercial driver's license test. There was no real training in backing up. One guy got hypothermia. I felt like after 8 months with them, I'd go running away screaming. They should call it crash and roll stunt team. Another former trainee, David Boyd, shared his experience of CRST's training with Time magazine earlier this year. He described how friction between co-drivers during the training could create severely dangerous working conditions. Boyd recalled being accused by a former co-driver of purposely hitting bumps while he tried to sleep, resulting in the driver wanting to physically fight him. Boyd also remembered one co-driver he connected with during his training at CRST, Aristides Garcia. Boyd had completed the training program and successfully received his commercial driver's license without ever having driven on an interstate, except during his test, and without knowing how to back up the truck. He said Garcia taught him how to do both. Tragically, in March of 2022, Garcia was found murdered by another CRST co-driver while on the road. And if that wasn't bad enough, CRST is also using traps to silence victims of sexual harassment and assault that occurs during their training programs. One woman, who was a student trainee at CRST, reported being raped by her trainer at the beginning of her 10-month training program. When she reported this to the company, she was told that without corroborating evidence like a video, the company could not do anything. After being effectively fired by CRST following the assault, she received a bill for $9,000 due to her trap. When she later sued the company for multiple causes, they settled for $5 million. However, the case revealed a much wider problem. There were up to 200 other sexual harassment claims involving CRST drivers. While the $5 million settlement may provide some semblance of justice, it's a bitter pill to swallow. No amount of compensation erases the trauma endured by the workers facing these horrors, and nothing will bring back Mr. Garcia. No one should be coerced into silence or feel trapped in unsafe conditions due to the fear of debt. And in spite of all this, the Biden administration and the U.S. Department of Labor announced a partnership with CRST as part of their expanded registered apprenticeship program to ensure high-quality training for new drivers and to help employers develop and retain a skilled and safe workplace. You can't make this shit up. Now, traps aren't the only tricks up the boss's sleeves. Consider the Southern California port truckers. These workers, often clocking over 16 hours a day, find themselves trapped in a modern-day hustle courtesy of a coercive lease purchase contract imposed by their employers. Trucking companies force drivers to finance their own trucks through unaffordable debt, resulting in forced labor and perpetual entrapment. And the consequences are dire. Take Samuel Talavera, for instance. Mr. Talavera worked brutally long hours and often slept in his cab in the company parking lot, taking home as little as 67 cents a week. When the truck he leased from his employer broke down, he couldn't afford to pay for repairs. So they fired him and seized the truck, along with the $78,000 he had paid towards owning it. And there are thousands of workers just like him, hauling containers full of goods from America's major retailers, including Costco, Target, and Home Depot. So what's being done about all this? Well, it's not so simple. After years of outcry, in addition to the CFPB's call to action, the FTC has proposed a rule to ban all non-compete clauses, including traps, but it's not binding yet. If the FTC issues the rule, private parties will certainly challenge it in the courts. The U.S. Chamber of Commerce has already signaled that it will do so, and there are good reasons to believe it won't survive in the courts. So far, only 3 states have directly addressed traps, with Connecticut and California prohibiting them only for certain workers. And some workers are fighting back with class actions. For example, PetSmart employees have sued the employer for an unlawful trap. However, forced arbitration is being used as a shield, preventing workers from challenging these practices in court. And even supposing these employees do see their day in court, it's hard to imagine that this is truly a systemic solution because it presupposes access to litigation, something that likely isn't feasible on any major scale. If you ask me, the best solution I can imagine lies in labor unions. Unions play a crucial role in advocating for workers' rights, pushing for fair wages, and challenging exploitative practices. As we confront the issues of coercive employment contracts, traps, and other forms of employer-driven debt, supporting and strengthening labor unions becomes a beacon of hope for workers seeking justice and fair working conditions. It's time to stand together, empower the workforce, and build a future where workers are treated with dignity and respect. Thank you for watching, and remember to support your local union.
Yeah, yo. Yeah, yo. Moo la la. Yeah, yo. Bitch better have my money. Y'all should know me well enough. Bitch better have my money. Play down, call me on my blood. Pay me what you want it. Ballin' bigger than LeBron. Bitch, give me your money. Who y'all think y'all frontin' on? Like blah, blah, blah.